the public protector and your team, led by Advocate Mpofu, evidence leaders, Advocate Bauer and Advocate Mayosi, South Africans, members of the public who are interacting with us. I certainly know that you tuned in 408 every moment of our hearings. Welcome. The media, the entire support staff, and as well as welcoming back our special guests who are with us for the second day. I won't go through your names today. Thank you. Welcome, Mr. Sphelo Samuel. Welcome back, Baba.
Thank you, Chair.
Thank you. We're going to start, and the day will be led, or a few hours will be led by Advocate Mpofu. But before I go to Advocate Mpofu, I am going to recognize Ms. Fatima Ibrahim, just to indicate to you members that as a chair, I would have received the written questions back from the public protector. And I've asked the committee secretary to immediately email and have copies printed for those of you who are here. But we've also agreed that as you receive those questions, we're going to ask the public protector to confirm those questions, Advocate Mpofu. Confirm the answers. Thank you, Advocate Bauer, to confirm those answers. And I'm going to ask Ms. Fatima Ibrahim to lead us in that.
Good morning, members. Thank you, Chair. Just for the record, these were the questions that followed the committee meeting on 15th of July, following Mr. van Lochenberg's evidence. Chair, on 16th of July, we addressed correspondence to the PP wherein we included all the questions as posed, and the PP then provided those written answers under cover of a letter dated 22 July. However, the responses were not in the form of a sworn statement as required by Directive 5.9. And furthermore, the letter also requested that the responses be kept confidential at that time. The reason proffered for same was that they should be kept confidential until such time as the objections in relation to the fairness of the process as articulated in their letter of 18th of July had been dealt with. By the time we received the response, Chair, members will recall that we had already prepared the letter of response. I discussed some of those preliminary responses in the meeting last week, Wednesday, and indeed that letter was already sent. We thus replied to the request saying that we are of the view that there is no legal basis to keep those answers confidential, and the Chair is in fact duty-bound to share that information with the committee. Chair, in the absence of that having been done in the form of a sworn statement, I'm now going to request that the PP kindly confirm for us that the written responses as submitted on the 22nd of July, a copy of which I think has been handed out to all members and the PP's team, is in fact her sworn response. And just to remind the PP that she is still under oath in terms of the Powers Act. So if we can please just get that confirmation, and then we'll add it to the record and to the bundle of evidence. Thank you, Chair.
Thank you, Ms. Ibrahim. Mkhwebane.
Thank you, Chairperson. I confirm under oath that the responses indeed were compiled by me and my legal team.
Thank you, Chair. That's in order. We'll now add it to the bundle. Thank you.
Thank you, Advocate Mkhwebane, and thank you, Ms. Fatima Ibrahim. With that done, I'm now going to invite Advocate Mpofu to start the cross-examination, and we will examine his time at 3 o'clock. Thank you. Go ahead, Advocate Mpofu.
Thank you, Chairperson. I can assure you that it's unlikely that we will finish at that time, but there's no harm in revising the program then. Can I ask for an indulgence, Chair, from you, just to, when we come to tea time, if you can just make it a relatively longish, maybe more than 15 minutes. There's just a document that I left in my hotel. So I'll have to go and quickly get it. Maybe
we'll consider that. Thank you.
I'm nearby, so
no problem.
20 minutes. Or actually, you can just make it your normal time. But if I come back late, don't hold it against me. Thank you.
No problem. Go ahead.
Thank you very much. Good morning, Mr. Samuel.
Good morning, Council.
Kunjani namhlanje?
Philile mkhulu. Fun nice one.
Oh no, I noticed khona. Kufuneka ndikubuza ngelimi lasemzini. So that bazosiva sonke namadlagusha. Okay, I was just warming up the witness. Greetings. Ngumnisidoko mhlanje. Isidoko sakho ngumni?
Oh, ngumqini.
Oh. Hayi ke lihlubi elithatha. Andazi ke lo mfo ujantshi ba ngumni isidoko sakhe. Usihlalo lo.
You did ask for extra minutes, so please don't get to those minutes.
I knew he was going to do that. No, thanks. Mr. Samuel, I'm going to try. Did you get your medication and everything?
Yes, I got
better now.
Thank you. Yes.
Thank you very much. All right, please, if you feel uncomfortable at any stage, just indicate. And I'm sure the chair will do whatever needs to be done.
Thank you.
Okay. I'll try and make this as easy as possible by front, which I've never done in my entire life, but telling you up front what theories and conclusions I'm going to try and persuade the committee to reach about your evidence. And if you agree with them now, then we'll take 10 minutes and then we go to call the next witness. I'm going to argue that you have no personal knowledge of all the information that you alleged in your affidavit. And that is mostly information that has been fed to you by the evidence leaders. Do you agree?
I will agree with you in part, but not entirely.
Not entirely.
I've stated that in my affidavit.
Yes, no, that's fine. In part, it's good enough for now. I'll also argue that you have not yourself familiarized yourself with the court decisions that you discuss in your affidavit, but that is just a way of introducing those court decisions into evidence via you. It could have been anybody sitting there. All you have to say is yes, yes, yes. Is paragraph this of this court saying this? Yes, yes. But then anymore, I could do that. In other words, there's nothing peculiar about you regarding those court decisions. You don't have a special knowledge of them. Maybe let me put it that way. Am I right?
That is correct.
Thank you. Okay, well, it will cut out about an hour, sir. Then I'm also argue that both you and the evidence leaders then in that endeavor have given us a skewed and unbalanced view of the public protector's achievements by only highlighting the negative, but not the positives. Will you agree partly, entirely, or not at all?
I do not agree. Can I qualify?
Yes.
It's in my evidence. I've stated that my laptop was confiscated and that in preparing my affidavit, I relied solely partly on my own recollection and also on the emails that were retrieved by the evidence leaders.
Yeah.
But some of which I did not get, as well as the some of the evidence, some of the records that would have been on my laptop. And to that extent, I have had to reconstruct based on memory and the available information.
Yes.
So I was not in any way persuaded to say whatever I said by the evidence leaders.
Yes. No, that's fine. I think we are misunderstanding each other here. That answer I accept for now, provisionally. But that's an answer to my previous question, not this one. That explains why you said you partly agree with me when I said some of the information came from them. That's fine. We'll come to that. I'm putting a different proposition. And for now, I just want to know if you agree or not so that I can cut out or put back that hour. I'm saying you and the evidence leaders, after all that you've explained, have given the committee a skewed and unbalanced view of the public protector's performance, that you concentrate only on the negative or what you perceive to be the negative, but not the positives. And that even goes to the court judgments. Where there are court judgments that are in her favor, you don't highlight them, neither do they.
I don't agree. I did concede that there were some positives that Advocate Mkhwebane brought in and that I agreed with. And so it's not entirely true that I only concentrated on the negatives. It might be that perhaps the negatives are more than the positives.
Okay, so it's partly true, but not entirely true.
Yes.
Good, that's good enough for now. And I'm also going to add that you, like Mr. Kekana, are one of the disgruntled employees who is bitter against Advocate Mkhwebane for maybe her management style rather than the issues that are pertinent to this committee. What will you say to that?
I would not agree. I have nothing personal or otherwise against Advocate Mkhwebane.
No, I didn't say personal. I said because of her management style and maybe some of the decisions she took that might have deprived you of claiming for travel and things like that.
I'll concede I'm very critical of her management style.
Good, that's good enough. And then I'm going to also argue at the end, and again, you'll save us time or some time or all the time, that the so-called reckless litigation that you talk about is nothing but a result of the fact that in 2016 there was the famous EFF Nkandla judgment, which then invariably caused more litigation against the Office of the Public Protector. What will you say to that?
I would concede that it did escalate the bringing of reviews against the office, but that right has always been there, even before that judgment. So it is not the sole cause of the litigation that was in the end of it. But my evidence was that we did not generally defend all litigation against the office, especially on reviews, prior to her arrival. because we're not a litigious institution. And so my argument when it comes to that was that this litigation that flowed from her approach was not in the office, was not in the interest of the office in all cases. It was instead, it had the negative effect of portraying the office in a negative light.
Yeah, no, that's fine. That might be the effect. We'll talk about that. I'm saying to you, and you're saying you'll partly agree. So I'm pushing you to agree more than that. I'm saying that a major cause of the rate of litigation was the new attitude of the people you were investigating, caused or rather encouraged by the EFF Nkandla judgment, which made remedial action binding. You can blame me partly for that because I was an applicant in that case. Yeah. Or rather, I was acting for an applicant.
As I said, I do not entirely agree.
But partly you agree?
Yes.
That it was, okay, I'll put it higher.
Perhaps I can put it this way, that perhaps it became more noted after that judgment.
Yes, no, fair enough. I'm happy with that. But I'm putting it higher than that. I'm saying that judgment was a turning point in respect of litigation against the public protector. Would you agree?
Yes, I would.
Thank you. Okay.
Sorry, just lift up your mic a bit. Thank you, so that even those in virtual can hear you.
Thank you, Chair.
Go ahead, Advocate Mpofu.
Okay, thank you. Chair, well, between you and I, it's a draw now. Because we had an hour that I took out, now I put it back, but I think so far we're doing well. But the next thing I'm going to...
I see that you even inspired by the color that I wear. Go ahead.
Our secret is out here. Thank you. Yes. Okay, now okay, I'm also going to add, this is not on my list, but it's just something I'm going to add, that you have a fertile imagination and you're a creative person. I'm not saying that in a negative way.
If you're not saying it in a negative way, Advocate, I will take this as a compliment.
Yes.
I do use my imagination.
Yeah, no, I agree.
Definitely not in a negative way.
Okay. Do you read spy novels and things like that?
No, I don't.
You don't like mysteries and that kind of thrillers?
No, I don't.
All right. I'll come to that. Then I will also say that, and this is, maybe it's linked to something I said earlier about the cases. I can't remember your answer. When I said you have not actually read these decisions as much as it would look if one reads your statement, what did you say to that? The court decisions.
My answer, now that you're rephrasing that question, my answer is that I am familiar with the cases, but I don't have in-depth knowledge of them.
But if somebody reads your statement, will think that you have more than in-depth knowledge because you quote this paragraph and that paragraph and that paragraph and link it to this paragraph, and then comes the conspiracy theory. Anybody reading your statement will be forgiven for thinking that you have read this judgment thoroughly and analyzed them. Would you agree?
No, I don't necessarily agree.
All right, we'll come back to that. Now, apart from not reading the judgments, have you read the independent panel's report?
No.
Do you know of such a thing?
Yes, I do.
Okay. And the most extraordinary thing about your evidence is exactly that. The fact that you traverse all these judgments, CX judgment, the Freire judgment, the CR17 judgment, the Financial Services Board and Conduct. Remember that one?
Yes, I do.
Yeah. You go into detail with all, in respect of all those judgments, and they have to say you haven't read them in detail.
Chair, I did read these judgments in the past, and as I said in my affidavit, what concerned me was the negative publicity and the way these judgments, the comments made by the judges panned out in the public. They had the effect of making the public lose faith and trust in our office.
Sure.
That is what I quoted in those affidavits. That's what concerned me. I agree. I am not fully conversant with each and every case, the detail that you're referring to.
Yes, well, I know that, and I'm going to demonstrate it, but I'm saying the impression you wanted to leave the committee with, so that they may find applicant Mkhwebane guilty of the charges that she's been charged of, which are mainly based on those judgments. You do know that the charges are mainly based on judgment.
Largely, yes.
Yes, mostly. Actually, yes. Okay, that's fine. I'm saying this, Mr. Samuel. If you had not come here, let's just say you had just submitted your 70-page affidavit, and the evidence leaders had decided not to call you as a witness, and neither do we call you as a witness. The impression left with the committee would be, here we have somebody, an admitted attorney at that, who is analyzing this judgment in great detail, and therefore, especially being a lawyer, we can take his evidence as more than just speculation, because here he's quoting chapter and verse from these judgments. And yet the reality is that you are not familiar with those judgments, and I will show you why I say that. Would you agree with that?
No, I would not.
Good.
I cannot speak for the committee.
Yeah.
I don't know how they receive this information. It is not for me to persuade them. All I'm doing is to testify to the best of my ability and account.
No. It is for you. That's exactly what you're trying to do, is to persuade them. Both your statements are intended for the impeachment process, no?
No.
So when you were saying in your first statement that you are prepared to make another statement for whatever processes might follow, and I'm paraphrasing, because that's the one that I'm going to finish at the time. What were you talking about?
My initial affidavit, it was accompanied by a covering letter. I specifically said, and also in the affidavit, my request to the speaker was to launch an investigation into the conduct of the public protector in how she's running the institution. It was not in any way intended for, certainly for this committee. I didn't have that in mind at the time. I didn't even know that it was going to come. What I had in mind was that the speaker would at least launch an investigation in whatever way. And when I got the response that it had been referred to the portfolio committee, I thought that committee would would launch the investigation. I did not prepare them for the impeachment.
For impeachment. Oh, I see. Well,
and yes, when I said at the end of my affidavit that I am prepared to supplement it in some way, perhaps not in so many words, but I was saying if more evidence is required of me, because at that time I still had my laptop and my other break. I'm willing to come forward with it and to testify, through the investigating team that I had envisaged might be sent.
I see. So when you say in the statement that you gave to this committee, when you say that was this statement you gave here is the one that was foreshadowed in your initial affidavit, that is not true.
You repeat the question, please.
You said you're making this one, which I have here with me. Okay, let me read it out to you.
Yes, please.
Paragraph 11 of your statement at 2072.
Are we able to have it flighted? Just to remind everybody. Go ahead, advocate, in the meantime.
Okay, yes. You say, as it appears that some of the grounds of alleged misconduct and incompetence against the PP, those are the grounds of impeachment. Do you agree?
Yes, I do.
Yeah. Appear to flow from my initial affidavit. The initial affidavit is the one of February 2020. Okay.
Correct.
The one you tell us had nothing to do with impeachment, but her impeachment process flows from it. Does that make sense to you?
To the extent that it was sent, it was included here and for me to come and testify, yes.
No, Mr. Samuel, please. I'm asking you a simple question. When you say that the grounds of alleged misconduct and incompetence, which are the grounds of impeachment, flow from your initial affidavit, a person reading that must understand that the impeachment charges flow from your affidavit.
Yes, that's what I'm saying.
Thank you.
I'm agreeing to that.
Against what you just told us 2 minutes ago, that the two had nothing to do with each other.
What I said was that affidavit was not meant for an impeachment hearing. It was meant for an investigation.
Okay, that's fine. I'll take that for now. But at the very least, we agree that the impeachment charges flow from the affidavit.
Well, my affidavit does make allegations of impeachable conduct, yes.
No,
That is the same as saying, yes, I agree. But as I say, I qualified
okay.
at the time, that was not my intention.
Okay.
I agree.
All right, yeah. You are a lawyer, so if you want to say yes, you agree, just say so. Don't say something that is the same as saying yes. Yeah. Okay. And then you say because it flowed from the affidavit, you deemed it necessary, especially in the light of the committee's rules. So you've even read the rules, the section 194(1)A rules.
They were explained to me.
By who?
By the evidence leaders.
Did you read them?
No.
So you put something in your statement, or was it put by the evidence leaders about rules that you have never read?
Yes, I've not read the rules, but I had no reason to doubt
what they were telling you. Yeah. And yet you saw to God that this statement was the truth.
Yes, I did. But I did say in the affidavit as well that some of the information is not my personal knowledge, and I've amplified it based on what could be recovered.
No, please.
And I considered that some of it might be hearsay, yes.
Yes, you said it's hearsay, but you gave the impression it was hearsay from your co-workers, not hearsay from the evidence leaders. You never told us in the statement that you had part of the hearsay was from the evidence leaders. Did you?
I did not. It's the first time you're asking me about that.
All right. I will say you deemed it necessary, especially in light of the committee's rules, to amplify the contents thereof. In other words, to add to your statement, initial statement, which flowing from the rules is the basis for the impeachment charges, correct?
Correct, yes.
Thank you. And then we say, hence, this supplementary affidavit, as foreshadowed in paragraph 6.2 of my initial affidavit, in order to further assist the committee to discharge its function. The function of this committee is to verify whether the public protector should be removed from office. That's the same function you're talking about, correct?
Correct.
Thank you. All right. Now, how did your initial statement end up with Ms. Mazzoni?
I have no idea. It's the first time I hear that it ended up with I sent it to the speaker, and as to what happened beyond that, I had no control. I don't know.
Yeah, no, because a very strange thing happened, and your comment, you've partly answered it. Is that Ms. Mazzoni put a motion for the impeachment of the public protector on the 6th of December 2019, 72 hours after the rules were passed by the National Assembly. Okay. And on the 28th, I think, of January, Chair, we will upload that letter. It was not relevant until now. We wrote a letter to the speaker, the then speaker, pleading with her that we should try and avoid this thing going to court and find a, we wrote on behalf of the public protector. And one of the issues that we raised there was the fact that the motion was in any event defective because it relied on court judgments, as you and I have agreed, all of which had preceded the 3rd of December, which was the date of the passing of the rules. Then as a lawyer, you understand, I'm sure you can see the problem already. So we lawyers, we like using big words. We call it retrospectivity, okay? So we made the retrospectivity argument to say, you can't pass rules on the 3rd of December and then charge someone for judgments that were in 2017 and so on before those rules came. You understand?
I do.
Right. That letter then caused something quite strange because your affidavit came on the 11th of February, correct?
Correct.
Yeah. And then on the 21st of February, Ms. Mazzoni withdrew her motion, right? And put a new one with the same charges, the same judgments, but this time it included your affidavit. In other words, the retrospectivity problem was now cured because there was at least one charge which was of something that came after the passing of the rules. You understand?
I do.
Yeah. So that's why I'm asking you this question, because it looks like it was just a whole contrivance to cure that problem. But I take your word that if it was, it was, but you were not part of it. You did not go to Ms. Mazzoni and say, here's a way out of this problem.
No, I did not.
Okay.
All I can say is that at that time, that affidavit and the letter were already in the public domain. Somehow I fielded questions in the press about that.
Okay, no, fair
And
enough.
even in that one, I don't know how
Yes.
it got to the
No,
news.
that's fair enough. Yeah. So maybe she just sees the opportunity. Okay. And of course, the speaker, needless to say, against our objections, accepted this new motion. And it was never explained why. In fact, that was the only reason, as far as we were concerned, that it was changed. And we said so under oath in the subsequent litigation. Right. Okay. Now, I was saying one of the most peculiar things about your evidence, which I found quite perplexing, is that, and that's why I told the chair in no uncertain terms that I'm unlikely to finish with you today, because you turned out to be probably the most important witness, in the sense that you cover all the key judgments from which, to borrow your phrase, the impeachment charges flow. Understand what I'm saying? Or I can explain it if you don't.
I understand, but it was not my phrase. You put it to me.
The flow. No, it was yours. It's on paragraph 11. The alleged misconduct and or incompetence against the PP appear to flow from the initial affidavit. When did I suggest that to you? Is it me or the evidence leaders? Are you mistaking me for evidence?
No, it is my affidavit. I'll own up to it. Yes,
Okay.
they appear to flow.
Yes. Okay. Please don't accuse me of things I have not
My
done.
apologies.
I'm not advocating Mkhwebane. All right. So I was saying, Mr. Sama, that the most remarkable thing about your evidence is that you cover the key, let me put it this way, the key court judgments on which Ms. Mazzoni relies for her motion, which has unfortunately been kept intact despite the fact that the independent panel tried to cleanse it. Is that some of the core judgments are the Freire judgment, the CX judgment, and the CR17 Busasa judgment. All the other charges are there, but the core of the business why we're here are those the findings made in those three judgments. Would you agree? Well, since you discussed, yes, oh sorry, and FCSA, yes, the PP just reminded me, and all four of those judgments discussed in your affidavit. Agreed? Yes.
Yes, sir.
Yeah. So that's why I'm saying no other witness, at least so far, is capable of almost, like if your evidence was believed, we could even just stop and impeach tomorrow. That's how important you are, because you cover the core of the charges. Understand?
I do.
Thank you. All right. Now, and I call that remarkable for a particular reason, because the irony of ironies is that your evidence from which Ms. Mazzoni found sufficient ground to include in her revised motion actually does not refer to judgments at all. Do you agree?
I do.
But somehow between you and the evidence leaders, the whole thing has transformed into this 75-page document which discusses those 4 court judgments, correct?
That's correct.
In fact, the independent panel made up of a retired judge and 2 senior counsel singled out your evidence as the only evidence which is not reliant on judgments at all.
I did not read that report, but I will take what you say if that is
okay. Can somebody put up paragraph 103 of the independent panel report? I rely on my learned friends to assist me to identify it.
Maybe in the meantime,
Okay, I'll just read it
it's
out
quite a short
to save time. Yeah, it's quite short. Yeah.
all but one instance.
Yes,
Just go through
yes,
that.
I'll just read it. It will be put up for the members later. Thank you, Chair. Just to save time. Yeah, it says the panel says in all but one instance, charge 4, the allegations of Mr. Sphelo Samuel, the member, meaning Ms. Mazzoni, intends that the evidence of the charges can be found in judgments or court papers. And they say, insofar as reliance is placed on judgments of court, we record that we are alive to the fact that the courts dealt with the conduct of the PP in a different context, and so on and so on. I've read that part already to the committee before. But the point I'm simply making to you now is that if you wanted any further proof that your evidence cured, quote unquote, the defect, the retrospectivity defect in the original motion, then here it is. Because, as I say, what we had pointed out in our letter was that all these judgments predated the adoption of the rules, and hence your evidence was put in. But the point I'm making now is simply that it was singled out even by the judge, the retired judge, and the 2 senior counsel as being the only piece of evidence which was not based on judgments. And yet, now, that was in 2021, okay? Now, here we're sitting in 2022. Your evidence is the one that covers the judgments more than any other witness. Big transformation, would you agree?
Yes, I would agree, but I need to qualify that.
Of course.
Thank you. The date of my affidavit is the 11th of February. And subsequent to that, the first time I referred to judgments and the scathing nature of the comments made by the judges was in my letter to the PP in March, where I asked her to resign. And so in preparing my affidavit, that was taken into account, that I'm making reference to cases, especially comments made by judges. And so that is why this comes into my affidavit.
Yes. Yeah. Well, that may well be so, Mr. Samuel. I'm not quibbling with that. I'm simply saying, to the naked eye, here's Mr. Samuel, the only person who doesn't rely on judgment for his impeachment efforts from which the charges flow. I'm simply saying a year later, Mr. Samuel is relying on judgments more than any other witness who is going to assist this stand under correction. Maybe there's going to be another one who comes with having read all the judgments or even more. But for now, you are the only witness who is the authority on this judgment. I'm just saying, surely you would agree with me that that's quite a big revolutionary change.
I will agree with you.
Thank you.
For now.
Thank you very much.
Just a pause, Advocate Mpofu, Advocate Bauer.
If I could just ask Mr. Mpofu to please reflect what's in the affidavit as closely as possible to the affidavit, because the judgments is not represented as being an authority on the judgments. It was simply put in as a section, and where he says it informed his decision. There is no reliance on the judgments in the affidavit other than in respect of his explanation and reckless litigation.
Okay, I don't think I need to react to that. We'll deal with it when we do legal argument. I'll take you through your affidavit. Do you agree with what the evidence leader has just said? There's no reliance on the judgments in your affidavit?
Yes.
No reliance?
No reliance except for the comments that were made by the judges.
But is there no reliance? That's what she said. Don't say except for, because if you say except, you might undo.
Now, Mr. Mpofu.
Go ahead, just pause, Advocate Mpofu. Go ahead, Advocate Bauer.
Through you, Chair, I qualified it by saying that the reliance on the judgments to which Mr. Mpofu is relating, when I said no reliance on the judgment, it was in the context of the section of reckless litigation. The proposition which Mr. Mpofu put to the witness was that he's an authority on the judgments based on his affidavit, and that's what that isn't what he said in the affidavit.
It's fine. Okay, that's fine. This is all clear in time. That's fine. I know what's happening. All right. Well, let's not be distracted, Mr. Summer. I'm not putting it any higher than this, really, and I don't think we should waste time on this. I'm simply saying the independent panel found it remarkable, well, literally, they made a remark about the fact that your evidence was the only evidence which did not hinge on judgments. That's common cause now. I've just read it out to you. Agreed?
I agree.
Now, I'm saying from that state of affairs to this state of affairs where, as I've described to you, you are the person, the only witness so far who has relied partly or whatever, but who have placed some reliance, maybe let me lower it to that, on the 4 core judgments before this court. Would you agree?
I'm not sure whether I'm the only witness who has done that.
Well, take it from me. You are. I'm saying, okay, assume if you are, then would you agree that that's major transformation, if I'm not making that up?
I think I've answered that question.
You think you've answered it?
Yes, I have answered that question. It's not the first time you're asking me that.
What's the answer?
It was that I'm not standing here, I'm not sitting here pretending to be an expert in this. Yes, I am relying on the comments made by the judge.
Good.
Yes.
You are relying on them. That's all I want to establish. Thank you. The other remarkable matter will be found in the fact that having looked at your And again, this committee has a different view, but that's a matter that might be resolved some other time. But you accept, or at least, and I'm not claiming you're an expert on this, but you have a basic understanding of how the process works. That there's Ms. Mazzoni's motion, it goes to an independent panel, chaired by a retired judge, 2 senior counsel, quite a serious and expensive exercise. But we're told it was, I don't know what was the purpose thereof. But anyway, they thought the purpose was to filter the motion and distill it for prima facie evidence. I understand that. It's like what happens in a court case. So, you pass section 174, if you pass, it's called a discharge. If you don't pass section 174, then you go into the real case. But if you win at section 174, you go home. Did you practice criminal law?
Yes, I did.
Okay.
I did.
That's why I'm making that example. Yeah.
Yes, I understand. But Mr. Mpofu, I'm battling to follow why I'm required to comment on the process that was undertaken by the independent panel, using partly my affidavit when I was not part to that. I did not refer to that to the panel. It was referred by someone other than me.
No, Mr. Samuel. No.
And as I've testified that my intention with lodging that affidavit to the speaker was to ask for an investigation, not to impeach the public protector.
Yes, but your intention now is for her to be impeached.
That is not my intention. My intention is to assist the committee with the allegations that I made. As to the conclusion that is drawn, it is up to the committee, not to me.
Okay, now you're splitting hairs, Mr. Samuel. Your intention is to assist the committee, and the function of the committee is to verify whether or not the public protector should be impeached.
Yes, that is their decision, not mine.
Of course, no. Believe me, that much I know. But I'm saying this philanthropic voyage is to assist the committee, not all the committees here in this building, but the committee that is designed to decide whether or not she should be removed.
That is correct.
And you say you don't know why I'm asking you about the process.
I'm referring to the process that I did not initiate, but my affidavit was used in that process. That is all I can talk about, my affidavit, but not why it landed to the panel.
Yes, but you gave the impression in the affidavit, excuse me, that you are familiar with the rules and the functions of this committee.
To the extent that they were explained to me.
Yes,
relevant parts. Yes, I'm not familiar. I'm not familiar. I don't know the rules, all of them. I cannot tell you that rule 1 or rule 4 says.
No, thank you. No, that you've said. In fairness, I'm saying that, but you've referred in your affidavit to the functions of this committee, and you would agree that they are as I've just described them.
I will accept what you're telling me.
No,
because I didn't read the rules.
No, don't accept anything from me yet. I'm accepting yours. You said at the end of paragraph 11, hence the supplementary affidavit as foreshadowed in paragraph 6.2 of the initial affidavit, in order to further assist the committee to discharge its function. It's you who said that. So surely then you know what the function of the committee is.
Yes, I do.
What is the function of the committee?
Is to determine whether or not the public protector has been impeached, or must be impeached.
All right. Anyway, let's not be distracted. You were saying, or rather, I was saying to you that the role of the independent panel, among other things, is to determine whether, because a motion can come from, a member might do a motion against me because they don't like me or whatever. And that's why we have to bring independent lawyers and even a judge to cleanse the motion so that whatever remains there is what should be, in other words, if it doesn't pass that stage, that's the end of it. That's why I was making the example of section 174 to you, but I don't want to confuse you. The only point I was making is the independent panel, for its trouble, decided that the only thing from your evidence which was worth inquiring into, or I should say the only things, that there were only two things. And those things you have actually not testified about. That's another remarkable thing. One was that the investigation into reinvestigating the project with specific focus on the role of politicians in the scheme was swept under the carpet. You said something to that effect. You remember that?
Yes, I do.
Yes. So that's one allegation which you made. Okay. You know that that allegation is false because that reinvestigation was actually done.
I'm aware that the reinvestigation was done.
Okay. So that we...
Just once, Advocate Mpofu, Advocate Mayosi.
Sorry to interrupt you, Advocate Mpofu. Can you just refer us to the paragraphs of the independent panel reports you're referring to?
No, not yet. I'm still cross-examining. I'll come to that. I will refer you when it's appropriate. Yeah. So far, we agree, Mr. Samuel. That was the first issue, the investigation. That was swept under the carpet. Those were your words.
Just switch on your mic.
Yes, at the time that I made that affidavit, I believed that the investigation was being swept under the carpet.
Yes, Mr. Samuel, don't get me wrong. I'm not attacking you at all. I'm simply saying that, or rather, let me say, I'm not taking your bona fides at the time. That would be unfair to use the status quo now to attack what you thought in 2020.
Yes.
No, that's not what I'm doing. I'm saying that you accept now that that allegation that reinvestigation was swept under the carpet turned out to be false. Not that you were lying, but it turned out to be false.
No, I don't accept that.
Okay. Do you accept that factually the reinvestigation was done?
Yes, I do.
Okay. Do you accept that it was not swept under the any carpet?
My belief is that there was pressure for it to be conducted and completed.
Yes.
Amongst other sources was the portfolio committee that impressed on the public protector to reinvestigate. Yes. And that's why it was done.
Yeah, no, you might be right, but please let's get the timelines correctly, okay? I'll remind you. So you did say that sometimes your memory is not good. Yes, you are right that the the portfolio committee impressed, let's put it that way, impressed upon the public protector to reinvestigate. And the public protector actually issued a statement to say she was going to investigate specifically this whole hullabaloo about politicians. Okay?
Correct.
And the officials involved. Remember, those were the big things that she did not investigate politicians and also did not deal with the beneficiaries.
Yes.
Yes. So you're quite right, I'm agreeing with you, that that complaint, which was the complaint that was bandied about mainly by the DA, even in the portfolio committee, was raised. But the point I want to just help you with is that it was raised in 2018, just so that you get your timelines correctly. Okay? I'm just telling you as a fact. Okay?
Okay.
If I'm making it up again, I'll be caught out. And then the investigation was conducted, the re-investigation. Okay? The public protector actually issued a statement to refute all these false allegations, giving the history that this investigation was actually started in 2014 by Advocate Madonsela. By the time she came at the end of 2016, it had been ongoing, and so on. And explaining that provisional reports are not reports for public consumption, as you know, at that stage before the Section 7-9 format was changed. Agreed?
Yes, I agree.
Yes. Now, if you accept what I'm saying as a fact, that so-called pressure that you are saying, let's, for argument's sake, let's say that is so, came in 2018, would you then agree with me that the reinvestigation, or rather, your statement that the reinvestigation was being swept under the statement 2 years after Advocate Mkhwebane had publicly said she was going to do it, was false, objectively false? Not, as I say, I'm not accusing you. You might not have known all this, but now that I'm telling you now, would you agree that it was untrue?
No, I don't.
Even so, your evidence, therefore, is that the reinvestigation that she was busy carrying out or had carried out was actually swept under the carpet.
I believe at the time, and as if I follow your timelines, we're talking 2 years, or maybe just about 2 years after she made an undertaking to reinvestigate, and it was not, she kept making statements that the investigation is ongoing, and as far as I'm concerned, there was no need for it to take that long, because it was straightforward to look at the role of politicians. Yes, I had the belief then that it was being swept under the carpet because it was there being investigated, but it was not, it was not being finalized.
Uh-huh. Oh, I see. So, okay, did you know that she was doing the investigation?
Yes, I did.
And when you made the statement that the investigation was being under the carpet, you actually knew that she was in the process of doing it. Is that your evidence?
Yes, sorry. Yes, I knew that the investigation was ongoing, but it was being swept under the carpet because it's not being finalized.
Ah. All right. So how long should it take? When you did the Friede investigation, how long did it take you?
My involvement started in 2015 when I relocated to the Free State, and that investigation was already ongoing. So my role, for me, it took just about 2 years.
2 years.
Yes.
And when Ms. Advocate Mkhwebane was taking about 18 months or so, she was sweeping it under the carpet.
Chair, you will recall that my evidence yesterday was that we made findings in my investigation. We made findings about the politicians. And to that extent, I don't understand why it would then take that long for her. And, you know, the evidence was that those findings against the politicians were removed from our report. Meaning they were there and they were not supposed to have been removed in the first place. So why would it take 2 years then to reinvestigate that part?
Is there something biting you there? You seem to be edgy, and that's it.
Yes, I'm allergic to this kind of information. No, that's fine.
You mean
Mr.
Oh, okay. Go ahead.
Thank you. Let me get it right. So when did the further investigation start?
My recollection is that it started, complaint was lodged in 2013. Yes,
2013. 2013, 14, 15, 16. So when Advocate Madonsela finished, it was 4 years in line.
When you say Advocate Madonsela finished, what is
Finished being a
term?
public protector,
Oh.
Mr. Samuel. When she finished her term.
I would say 3 years, not 4 years.
3. That's fine. Let's leave it 3. Okay. And she was not sweeping it under the carpet.
No, she was not.
So 3 years is not sweeping under the carpet, but 18 months is. Or less, actually. That's why, sorry, Chair, that's why I was looking for my phones to actually get the actual period. That's what was biting me.
My evidence, Chair, was that Advocate Madonsela kept sending it back because she was not happy with the fact that the role of politicians was explored. So she did not, she you know, and that's why she escalated it to me to supervise and investigate.
Yes.
So by her conduct, her constant monitoring, I don't believe, because I was still involved then. That
All right.
she swept it under.
That's fine. That's fine. So I see. So effectively, what you are saying is that this issue of attending to the politicians should take how long for it not to qualify as being swept under the carpet?
I cannot say it should take 2 months or 3 months or whatever, or a year, particularly because when she was reinvestigating as a public protector. She had all the powers that I did not have, but I had asked her to assist with as in issuing subpoenas against the politicians. So it could have been done quicker. Because she was now investigating with all the resources that I did not have. So my answer is that it should have taken, it shouldn't have taken as long as it did.
How long
up to the time that I felt that it was being swept under the carpet.
Yes. When did you start feeling that?
Around the time that I deposed to that affidavit.
February 2020.
Yes.
Yes. Just okay. Sorry, Chair.
In the meantime, up there's somebody who's doing a lot of movements. You are disturbing us.
Yes.
We want to
Okay.
focus here.
Anyway, okay, we'll come to that after tea, just to save time, Mr. Samuel. So you are unable to tell us, give or take, how long it should take just to attend to the issue of politicians?
Yes, sorry. Yes, I'm unable to tell you how long it should take.
Sorry?
I am unable to tell you how long it should take.
Okay,
That is
but you surely are able to tell us how long it took you to read it as being swept under the carpet.
Yes.
How long?
It was almost 2 years since she had started reinvestigating the role of politicians.
Okay, it was less than 2 years. It was about a year and a bit.
Yes, I'm only working on the years. I mean, it's 2018 to 2022. So I'm not
December 2018 to January 2020. You call that 2 years?
No, it's not 2 years. But as I say, I'm explaining that. I mean, earlier on when you also made a similar argument, you even mentioned the years one by one, 2013. 15. I mean, if we were to go back to the months Advocate Mpofu, I would say the same thing to you that it's not 3 years or 5 years.
But that's why I agreed with you.
I'm explaining, yes.
That's why I agreed with you, because on my wrong calculation, I said.
Okay, you just have to wait for each other because we can't hear you now.
But I'm saying that, Mr. Samuel, that's exactly why I considered the point to you, because I was saying 4 years. Using that method, and you corrected me and said 3 years, and I said fine, let's make it 3 years. So let's use the same methodology. Let's not shift according to when it suits us.
Yeah, no, I'll also consider.
Thank you. All right. Now, I don't waste time on this. All I'm saying is I will argue at the end that you applied double standards. And let me just develop the point. We can agree, disagree. On your own version, Advocate Madonsela sat with the investigation for about 3 years. Okay? And at some stage, she was unhappy, particularly about the issue of politicians, correct? And she escalated it to you, right?
Correct.
You took about 2 years and just to deal with that issue, correct?
Correct, yes.
Yes. And I'm saying Advocate Mkhwebane took less than both you and Advocate Madonsela, but you say she's sweeping the thing under the carpet. Isn't that a bit much?
As I said, she had resources that I did not have. It should have affected my timelines as well.
All right. So it was a question of resources. And Advocate Madonsela and Advocate Mkhwebane had the same amount of resources, correct?
Correct, yes.
And one of those resources was you, correct?
Correct, yes.
All right. Anyway, we'll come back to that if we have time. I was just simply saying, Mr. Samuel, that with all that debate that you and I have had, forget about the times and 3 years and what have you for now. But sitting there now, you know that the reinvestigation was actually carried out.
Yes, I do.
Yes. Therefore, this committee should not be under the impression that the reinvestigation was swept under the carpet.
The conclusion, yes.
Yes, thank you. Fine. Now, so that was the issue that the independent panel thought this committee should busy itself with. But you and I have now agreed that we can throw that one in the dustbin. The other issue that the independent panel felt that it should come here. Not all these other things. Actually, the independent panel felt that all these other things should go down to the dustbin of history, but the committee has decided otherwise. So the only other issue that the independent panel wanted to be brought here, flowing, to use your word, from your statement, was the fact that former minister or former MEC Msebenzi Zwane attended the birthday party of Advocate Mkhwebane. You remember that?
Yes, I do.
You remember that you raised that?
I did, yes.
You remember that you are the cause for that to be part of the business of this committee? Or at least I can tell you that for free. You are the cause of that issue being in front of this committee.
If it is in front of this committee,
Well, it should-
and it came
Yeah.
from me.
No, it should. Well, Mr. Samuel, on that one, you'll forgive me. This committee has its way of.
Just allow him to conclude his.
Okay. Oh, I thought you had concluded. I'm sorry.
No.
I'm sorry.
As I said, when I prepared my affidavit, my initial affidavit,
Mm.
it was not with the purpose of it serving in this committee. I did not even know about this committee then. All that it, and I want to believe it was not even formed at the time. All that I wanted was an investigation, and I made reference to her socializing with this particular politician, amongst others. And that information at that time was also in the public domain. I was certainly not in that party, but I got it from the media as well.
Okay.
So to the extent that it now forms part of the committee, I will take your word for it. I don't know. I'm not aware that it is, but if you say it is, then I'll accept it.
Yeah.
Yes.
No, you can take a word from me. I was at the party, by the way. So the point I'm only making to you is this. Again, I accept what you've just said now. But at least you must also accept that this committee, this august committee, doesn't sit here just to listen to, at least shouldn't sit here just to listen to things just because they are in the public domain. Because they come through a motion by a member. So again, I'll tell you how it got to be how it was supposed to be in front of this committee, but the committee, it's not, you're right. But that's a story for another day. Is that Ms. Mazzoni took your statement, as I've indicated earlier, and put it as part of her new motion, okay? And therefore, the issue of the birthday party attendance became a charge, right, or part of a charge.
It's just a pause before you respond. I recognize Advocate Mayosi.
Advocate Mpofu, the issue of the attendance of the birthday party, can you just point us to where it is a charge in the motion?
If you just bear with me. As you sit here now, you don't seriously suggest that the Advocate Mkhwebane must be impeached and removed from her office because Mr. Zwane attended her party.
It is not for me to determine whether she must be impeached, as I said, and if that conduct is objectionable and is impeachable, it is for the committee to decide.
Fine.
Not
No, fair enough. But as you sit now here, is it your testimony that one of the things that the committee should consider to make that decision, which I agree is their decision, or rather, one of the things you regard as misconduct and incompetence, to use your words from your affidavit, is the fact that former Mrs. Zwane attended a birthday party?
the conduct that I find objectionable with that was and is even today the fact that you cannot socialize with a person that you're investigating. It's a sign of conflict of interest.
I see. I see. So that was your only objection?
Yes. One of the issues I might add that reinforced my belief that the investigation was being swept under the carpet.
Yeah, now let's break that down into its constituent parts. So, that answer then means that you knew when you were doing your affidavit that there was an ongoing investigation.
Yes, I knew.
And so you knew that that investigation had not been swept under the carpet, or at least had not been successfully swept under the carpet.
Let me explain.
Yes, please do.
My belief. I believe you cannot sweep something that you're not busy with under the carpet. It can only be something that's supposed to be ongoing in the context of that investigation. So if the investigation is not finalized and there's this type of conduct by the person who's ostensibly doing an investigation, socializing with the subject of the investigation, and it's taking the time that it took, my belief was that it was being swept under the carpet because it is not being finalized. Yes, it was ongoing, but not being finalized.
I see. No, sorry, forgive me. It's the Bantu education. It's the Bantu education. So your allegation was that she was sweeping it under the carpet. It was not already swept. It was not already under the carpet.
It was an ongoing process. Yes, she was sweeping.
Right. It's my fault and that of the independent panel and your computer, because everywhere it says it was swept under the carpet, but that's fine, we'll come to that. I was just saying the following. Before we go back to the sweeping, as you are sitting here, is it your evidence, or rather, is it your conviction that simply because of the attendance of Mrs. Zwane of the birthday party, that amounts to misconduct? I don't want to put it higher than that. Or one of your instances of misconduct or incompetence?
No. My evidence is that it amounts to a conflict of interest.
Okay, fair enough. Which is not impeachable conduct.
That was not my allegation.
Yes. No, I'm not asking about intentions. You don't think it's impeachable conduct?
Sorry.
Yeah, no, fair enough. You've said that before. You don't think it's misconduct? or incompetence?
It is, I would say it is, it results in incompetence to appreciate one's role, and therefore might be misconduct.
Okay. Which part, incompetence on whose part?
The role of the public protector.
So the public protector is incompetent because somebody attended her party. That the sum total of this parliament must consider.
Somebody who she was investigating attended her party, and so it created the impression that she was protecting that individual. Or she might be protecting that individual.
How old are you, Mr. Summer?
57.
When is your birthday?
16th February.
Why are you looking for a birthday now, African Mpofu?
Well, we're talking about birthday.
Yeah, no, but he's just told you his age.
All right. So if somebody attends your birthday party on the 16th of February next year, or if I attend your birthday party, I just rock up there. You didn't invite me. What must you do? Run away. If you don't run away from your own birthday party, you will be incompetent.
Just suppose power.
I just get clarity. Is it the public protector's version that Mr. Zwane was at the party and that he rocked up there uninvited? Is that what's being put to the witness?
Yes, it's exactly what's being put to the witness. Okay. Yeah. And the first one is not just public protector's version. I was there as well. I saw him. So you can call me as a witness. All right. Okay. Now,
Just pause, Honorable Maila.
Okay, I'm sorry, I'm a little bit lost here, and I'll tell you why. I'm not sure where in the charges it relates to then MEC Zwane attending public protector's birthday party. I'm not finding that in the charges at all. So I'd just like some clarity. I'd like to be pointed to that. It follows what Advocate Mayosi was asking earlier, and we didn't get a clear answer on that.
yes. No, it was, thank you, Mr. Malam. No, it was contained in Ms. Mazzoni's revised motion. Maybe you can try and find it.
Can you point me to that in the charge sheet, please?
Okay. Yeah.
Let's do this because I was going to come back on Advocate Mayosi's before he came in, because he would have asked that question and you said you're going to just
Yes, I was going to, and Ms. Mayosi was kindly
what I want to
avoid. Patient.
What I want to avoid is those kind of it was all what it takes is a reference where that is, so that we don't go into the afternoon with that not being responded to.
Yes.
I'm not asking you to respond to it now.
No, I will, because I think
what I'm asking, if you can
sorry, sir.
pause, was she would have asked even a question before that, and you had a similar response about you going to respond to it.
Yes.
And time lapsed without that, because it is about dealing with that issue and then we don't pack it unnecessarily for
Fair enough.
for further. So, but Advocate Mpofu, at this time we will pause.
Please, can I just add this part?
You,
I'm begging you, just so that we don't, I'll just go to that reference.
okay.
Because I think it's burning Mr. Milam, and Ms. Mayosi was patient enough, so I don't want to stretch everybody's patience. If you go to paragraph 183 of the independent panel's report.
No, let's wait and
No,
hear
please.
what he's saying, please.
I mean, You know, one.
Just switch on your mic.
Okay.
Please switch off your mic, Honorable Milam. Continue, you were saying?
Thank you. I was saying, if you go to page 82, paragraph 183, I think everyone knows, even a 2-year-old child, that the independent panel was working on the charges that came from Ms. Mazone. Okay, it says this, having had regard, have you got it? Yeah.
Yes. It's 183.
Yes. Okay, sorry, just for context, can you quickly...
Paragraph 183.
183, Judge. Sorry, can you quickly just roll back to 178? Just for context, Chair.
That's no problem. No problem. 178, this component of charges.
Yes.
Okay.
Just the heading.
The heading is somewhere.
Yes. Just want to say, this is where the independent panel is dealing with Mr. Samuel, Honorable Member Malham, the evidence that he has supplied. And then go back to 183. Then it says, having regard, Chair, again to save time, can I start reading? Even though it's not up. Yeah. Having had regard to the allegations, in other words, to all your allegations, Mr. Samuel, we find prima facie evidence of misconduct in only one respect. Okay, says the independent panel.
You can just enlarge it.
Enlarge it, yes, too small. I'll carry on reading. Samuel, it says, Mr. Samuel, you'll see it just now, mentions that after the query by the Portfolio Committee on Justice and Correctional Services, through which the PP accounts to Parliament, the PP undertook to reinvestigate the project with specific focus on the role of politicians in the scheme and to interview the beneficiaries. We've agreed on that, you and I. Yeah. Samuel then alleges that the investigation was swept under the carpet. So it was already under the carpet. Despite some of the findings in respect of Mrs. Magashule and Zwane being made in staff reports submitted to her, the PP. We'll come to that, that's false as well. But that's not the thrust of what we're doing. And then here's the part, the birthday part, Honorable Member. The same Mr. Zwane is said to have supported the PP by attending her 50th birthday party that she hosted. Okay? Now, the only point I was making, well, not to Ms. Myers, because I think that's the part you wanted, but to the Honorable Member, is that all that came from the charges. But there's more, as they say in the advert. All that and more. Then you get the independent panel then summarizes. In fact, it thought it was assisting this committee, but it was making a mistake. It had something called Annexure A, which is at 117. Go to paragraph 117. I'm sorry, not page 117. Of the report here. Paragraph 262.
Yes. No, you want to continue?
Yes, okay, Chair. Yes, I'll paraphrase while they're busy with that. Okay, Annexure A to the independent panel chairperson is the summary by
Yeah.
the independent panel, which, as I say, was hoping to help this committee so that you know where did we find prima facie evidence. So if you go to are you there? Yes. So that's
As long as you know that whatever they were doing, it was not meant for the committee, it was meant for the National Assembly.
yes.
Because the committees arises out of the National
Correct,
Assembly. So
correct.
let's just
Yeah, no, yeah, you're
the
right.
correct reading of those
Yeah,
issues.
100%. It was the National Assembly, and this committee is the child of the National Assembly. So by extension, whatever the National Assembly was doing translated to this committee, but we'll leave that for argument, maybe not even here. Go to 263.8. I don't know why I couldn't look.
You said 263.
It's because my glasses are 263.8, Chairperson. 0.8.
Yes.
Go back, yeah. So when they summarize for the National Assembly, their findings, this is what they say. So they say on this charge, on this charge, on this charge, and this will now assist the honorable member. Under charge 11.3, Honorable Malham, then they say Samuel, that's you, right? So they say these are the things that, whether it's prima facie evidence which must come here or to the National Assembly, sorry. Yeah. Sweeping investigations under the carpet, okay? And that is, remember it said swept. So that means her action of having swept the investigation under the carpet. And then, so that's the big one. And we've all agreed, you and I have agreed that that thing is not just under the carpet, it's now in the dustbin. So having the person she is investigating at her birthday party, so it's 11.3, there's your answer, Honorable Mike. Charge 11.3. Okay.
Yes.
Chair, the only person who's brought this birthday party into this discussion is Advocate Mpofu. Chair, if you follow the evidence and the charge sheet makes no reference to the birthday party. The evidence leader never brought the birthday party in here. The only person who's brought the birthday party in is Advocate Mpofu.
Yes.
If Advocate Mpofu hadn't brought it in, we wouldn't even be considering the birthday party.
Okay.
But he's brought it in, and now he's trying to knock it down. It's like setting up a straw man.
All right. Yeah, he's brought it in and he's now elaborating where the origins of this are, and he points us to the independent panel report. So I don't know if we have to make a fight about that, because he's referencing his own issue. Honorable Heron.
Yeah, Chair, I think the whole record that we have to consider includes the affidavit, and the affidavit makes reference to the birthday party. So I think Honourable Malham is incorrect.
That's fine. Thank you, Honorable Heron.
Yes,
Advocate Mpofu, I want
think
us to pause there.
Yes,
now,
I'm happy with that.
and I'll give you that 5 minutes. We'll brace for tea now, and we'll be back at 12, honorable members.
Thank you.
Chair, when you come back, you must call Honorable Mayhem to order. This thing of him interrupting is wrong.
Recording
It's wrong,
stopped.
Chair. You must make a ruling on it, please.